Welcome everyone to our third presentation in ALTA's 2021 Commercial Network Webinar Series. I'm Jeremy Yohe, ALTA's Vice President of Communications, and today we're going to discuss the recently updated and published ALTA loan and owners policies and associated endorsements. And dig into how these new forms will impact commercial transactions. Before we get into the presentation, I need to touch on a few housekeeping items. As you know, with our webinars, all participant lines are muted for the discussion. If at any time you have a question, submit them in the questions box. We'll hold a little time for Q&A at the end of the presentation. The webinar is being recorded, and you can always go to ALTA's website to find the archive of presentations at alta.org/webinars. You'll also get an email tomorrow with a link to the recording. In the meantime, you can download a copy of today's presentation from the handout section, and the email you get tomorrow will also include a link to access the PDF of the presentation. Do need to thank SoftPro for sponsoring today's commercial network webinar. And before getting into the presentation and introducing the speakers, we do have a short message to play from SoftPro. All right. Thank you, SoftPro, for that message and sponsoring today's presentation. Now let me introduce today's speakers. Join us. We have the luxury to hear from two industry experts in this area. Both serve on ALTA's Forms Committee and have been deeply involved in the development of the 2021 Policy Forms Collection. First, we have Wendy Gibbons. Wendy is Deputy Chief Underwriting Counsel for Old Republic National Title Insurance Company. She has nearly 30 years of industry experience, and in her current position, Wendy underwrites transactions throughout the U.S., specializing in multi-state portfolio deals. And also joining us is Jan Ferris. Jan is a senior underwriter for Old Republic Title's Western Division. Her responsibilities cover everything from troubleshooting issues on residential closings to underwriting high-profile commercial transactions. Jan started her career in the industry as a courthouse abstractor in Detroit in the late 1970s, and has since made her way out to San Francisco. So, thank you both for joining us today. We have a lot to learn today, and before we get into the presentation, Wendy and Jan wanted to set the tone and let you know that everything's going to be all right. So here we go.
Thank you, Jeremy. Like Jeremy said, we're here to tell you it's going to be all right. We're going to focus today on how commercial transactions will be impacted by the new 2021 forms. The ALTA Forms Committee members, under the leadership of Chairs Paul Hammond and Jim Gosden, have worked very hard over the past several years to come up with the best possible product for the market that improves the protections afforded to our insureds. You'll find today that the new 2021 policies contain expanded insuring provisions and conditions intended to enhance the coverage that is beneficial to owners and lenders. Next slide. We'll focus today on the significant changes to the base owners and loan policies, which are the standard forms used in commercial transactions. For a line-by-line comparison of all the changes, you can go to the ALTA website under policy forms, where there's a 2006 versus 2021 policy comparison chart. We will also discuss the revisions to commercial endorsements. As many of you are aware, ALTA recently published the ALTA 2021 forms collection on July 30th with an effective date of July 1st. That date is the date that the forms were approved by the ALTA board. It's anticipated that it will take 1 to 2 years for insurers to file the forms in states where required, and for issuing offices to coordinate with their software vendors to upload the forms into their systems. Therefore, the decertification date for the 2006 policy forms is December 31st, 2022, which should be sufficient time for the rollout. We expect during the transition period that lenders and other customers will accept either form depending on availability in particular states. The 2006 forms can still be used after the decertification date, but as the 2021 policies contain better coverage for customers, the 2021 forms should become the default policy in commercial transactions. Next slide. So before we talk about the substantive changes to the forms, I wanted to talk a little bit about the road to the new forms and how they get adopted. The review of the forms is ongoing, with changes being made approximately every 15 years. The prior version of the base owners and loan policy was adopted in 2006. The ones before that in 1992, and in between there were various revisions, technical corrections to the existing forms, and the adoption of the 2016 commitment. The ALTA Forms Committee is charged with reviewing the existing forms and proposing new forms. The Forms Committee then provides its recommendations to the ALTA Board for adoption. The forms are posted for public comment for a period of time. Any comments are reviewed by the Forms Committee and addressed. The ALTA Board gives final approval, and the final version is posted with an effective date. And finally, industry rollout begins, which is where we are now. Next slide. The 2021 forms collection is a culmination of years and years of work, and is a collaborative effort among the ALTA Forms Committee, ALTA Underwriter Section, and the ALTA Board. Comments are actively sought from our industry partners, American Bar Association, American College of Mortgage Attorneys, American College of Real Estate Attorneys, Mortgage Bankers Association, as well as the GSEs, Fannie and Freddie, and FHFA, whose guidelines are tied to the issuance of policies and certain title insurance coverages that they require. Next slide. The changes are made as a result of changes in federal law, new court decision, and litigation in federal or state court or bankruptcy court, changes in operative law, which means the law applied to interpret the policy, which Jan will discuss further later, and any changes in federal regulations. Changes are also a result of comments and concerns received by ALTA members, our industry partners, and the GSEs. And I'll turn it over to Jan.
Okay, next slide, please. All right, we're gonna, starting at the beginning, the introductory paragraph of the policies contains a new clause, is highlighted, that provides the policy is valid even if the policy is issued electronically or lacks any signature, which of course is by and large the case for all policies issued at this point in time. This new clause negates the necessity for the ALTA 39 policy authentication endorsement, which has been issued with pretty much every policy for years now. So good news, the attorneys don't need to check off that box anymore. So next slide, please. Now we're going to take a look at the changes to the covered risks in the new policies. And let's first look at the highlighted modifications to covered risk 2, which provides insurance against defects, liens, or encumbrances on the title. Specifically, under covered risk 2A, Romanet 3, we've clarified that this applies to documents that have not been properly authorized. And we further specify that the coverage relating to proper notarization includes documents notarized with RON, or remote online notarization, which, as you know, became one of our best friends in 2020. Romanet 8 of covered risk 2A provides coverage similar to that of Romanet 3, but also includes coverage for the repudiation of an electronic signature. And then with respect to covered risk 2C, which relates to matters that would be disclosed by a survey, the 2006 version of this covered risk only referenced encroachments. And this new version specifies that the coverage is not limited to encroachments, but is also intended to cover any encumbrance, violation, variation, adverse circumstance, or boundary line overlap that would be disclosed by a survey. Excuse me. Next slide, please. And covered risks 5, 6, and 7 provide coverage for matters related to the enforcement of governmental powers is the impact title, but only to the extent that the matter in question is disclosed in the public records by proper notice and not shown as an exception in the policy. So to further clarify this coverage, the policies have redefined the definition of public records to clarify what we mean by that term. And simply put, we make it more clear that we're not talking about just any sort of records that might be available to the public. Also included for clarification purposes is the new defined term enforcement notice. And in the lower box of this slide, the definition is recited for your reference. Bottom line, if the policy includes an exception for an enforcement notice, the matter is not covered. The potential coverage arises if the enforcement notice is somehow missed and not shown as an exception. So I'd also like to bring your attention to the new defined term PACA and PASA trust referenced under Romanet 3 of the enforcement notice definition. And Wendy will be discussing the PACA and PASA trust issue next.
So new coverage is added in covered risk 8 in the owners and loan policy for enforcement of a PACA and PASA trust, but only to the extent that there is an enforcement notice recorded in the public records. And Jan just discussed those two new definitions for enforcement notice and public records. The 2021 policies also add a new definition for PACA and PASA trust, described as a trust created under the Perishable Agricultural Commodities Act and the Packer and Stockards Act, both of which are federal statutes and very old laws on the books. And the definition also includes trusts created under similar state or federal law. Now, both of these acts create a floating trust that operates similar to a lien, although it is not actually a lien, on all assets of a purchaser of specified fresh fruits and vegetables under PACA and livestock under PASA in the event the seller is not paid. Evidence of a PACA or PASA trust may be disclosed by a recorded lis pendens, a court order, or a complaint disclosed in the courthouse records, or an adversary proceeding in a bankruptcy. Examples of commercial properties that the PACA coverage would be relevant to are large grocery grocery store chains or fast food chains, or a tomato sauce manufacturing plant that purchases bulk fresh produce that's covered under the Act. Examples of commercial properties that the PASA coverage would be applicable to would be a slaughterhouse or a meat packing facility. Next slide.
Okay, so covered risk 9, and this slide just pertains to the new loan policy as it relates to ensuring the validity and enforceability of the lien of the insured mortgage. As you can see, the changes made under this covered risk 9 are essentially the same as those made under covered risk 2A for title defects discussed earlier in relation to RON and electronic transactions. Next slide, please. And here we have an expanded version of covered risk 10 of the loan policy. The prior version of covered risk 10 just stated the lack of priority of the lien of the insured mortgage upon a title over any other lien or encumbrance. The new version of covered risk 10 explicitly ensures the priority of the lien of the mortgage of the insured mortgage for the listed components of the indebtedness shown as paragraphs or subparagraphs A through E here. This is intended to clarify the types of advances that are included under covered risk 10. For instance, covered risk 10 was never intended to cover construction loan advances, which are addressed by covered risk 11A. And this new explicit listing of components makes that clear. Other examples of loans that include advances that don't fall under covered risk 10 would be revolving credit loans. So in the case of a revolving credit facility, the parties would need to obtain one of the ALTA 14 series endorsements or similar type of endorsement available at the state level for the insured lender to receive the priority coverage it needs relative to those future advances. Again, these types of advances were never included under covered risk 10, but the covered risk as rewritten makes that crystal clear. Next slide, please.
So the next covered risk we're going to talk about is the creditor's rights coverage. The new forms have improved creditor's rights coverage, appearing at covered risk 13 in the loan policy and covered risk 9 in the owner's policy, and these are commonly referred to as the back chain creditor's rights coverage provisions. Both the owner's and loan policy provide creditors' right coverage for conveyances in the back chain occurring prior to the current transaction, creating the interest to be insured. In the 2021 policies, coverage is expanded to provide coverage for the effect of a court order providing an alternative remedy resulting from an avoidance of a transfer as a fraudulent conveyance or preferential transfer under state and federal bankruptcy law. And this would apply to Section 550A of the Bankruptcy Code, which authorizes the bankruptcy trustee to either recover the property itself for the benefit of the bankruptcy estate, or if the court approves, recover the value of the property. Additionally, creditors' rights coverage is updated to provide, and you can see there in the highlighted Romanet A2 and 9A2 below, that voidable transfers under the Uniform Voidable Transactions Act are now covered. The UVTA has now replaced the Uniform Fraudulent Transfer Law in 21 states, and the policy has been amended to reflect that. The creditor's rights coverage risk also provides the insured with coverage if the current transaction is set aside or avoided under federal bankruptcy laws for failure to timely record the deed or mortgage conveyance. New language is added in 9B2 that clarifies the common meaning of timely recorded to say that timely recorded means it takes place after execution and delivery of the instrument to the insured. Next slide. Now we're going to talk about the policy exclusions.
Okay, so yes, moving on to the exclusion, we again have some clarifying language added to exclusion 1, which relates to governmental authority matters affecting title. First, the word remediation has been added under Romanet 4 of exclusion 1A to make it clear that the term environmental protection includes any required remediation. Then exclusion 1B has been clarified as well to add specific references to governmental forfeiture, regulatory, and national security powers, which again have always been implied but are now specifically set out. And just to tie back to our earlier slide discussing enforcement notices in relation to covered risks 5 and 6, again, the matters shown in exclusion 1 are excluded to the extent that there is no recorded enforcement notice for which we do not have a Schedule B exception. Next slide, please. Now, next, we're going to take a look at the updated creditors' rights exclusion, which relates to potential creditors' rights challenges to the current transaction being insured. First, under exclusion 6B of the loan policy and corresponding exclusion 4B of the owner's policy, we have an additional reference to a voidable transaction under the Uniform Voidable Transactions Act, which has been adopted in at least 19 states and is an amended version of the Uniform Fraudulent Transfer Act. Second, exclusion 6C of Romanet 1 of the loan policy and corresponding exclusion 4C Romanet 1 of the owner's policy have been added to clarify the exclusion of liability for a voidable preference claim arising because the transfer was not a contemporaneous exchange for new value, regardless of the subsequent timing of recording. So in other words, if the actual loan funds or consideration for the sale are dispersed before either the lien of the mortgage or the title to the property is perfected by the delivery and recordation of the mortgage or the deed, as the case may be, any related creditor's rights challenge based upon that delay of the delivery and recording of the documents is excluded from coverage.
And to correspond to the covered risk for PACA and PASA trust, there's a new exclusion for any claim of a PACA or PASA trust, which appears at exclusion 7 in the loan policy and exclusion 5 in the owner's policy. The exclusion specifically does not limit or modify coverage provided in the new covered risk unless an enforcement notice is recorded. As many of you may be aware, the PACA-PASA risk has been generally accepted in Schedule B in commercial transactions as a result of claims and case law in some state courts and bankruptcy courts, which have held that secured creditors lose out in priority to a PACA or PASA supplier who becomes first in line. Assets subject to the trust for PACA and PASA include assets bought with proceeds from resale, including real estate. As a result of this change in the exclusions, a specific exception in Schedule B for any loss or damage arising out of a PACA-PASA trust no longer needs to be raised, since the exception is now built into the policy jacket. For the types of commercial properties that we discussed previously where a PACA or PASA trust would be applicable, customers may still request affirmative coverage over potential PACA-PASA claims in states where custom coverage is permitted, and whether any coverage can be provided will be at the discretion of individual underwriters and in compliance with their underwriting guidelines and state regulations. Next slide.
So the last exclusion we'll be reviewing here is exclusion 9 of the loan policy and corresponding exclusion 7 of the owner's policy. This is a brand new exclusion added in order to specify that the policy does not insure the acreage or quantity of the land or of any improvement. So this alleviates the extra step we often need to take of adding a specific exception to the policy when the legal description includes a reference to acreage or square footage. So with this new exclusion, we no longer have to be concerned about any such references in the legal description.
And now we are going to switch over to the changes to the schedule of the policies.
Yes, now on to Schedule A. And there's now an option to include transaction identification data, which should be a handy reference for a multitude of purposes, both for the insured and the insurer. So the brackets around it indicate that its inclusion is optional based upon the company's preference. But in the event the company does decide to incorporate this data in Schedule A, you'll note that it includes a disclaimer to the effect that the insurer assumes no liability for its accuracy.
Schedule B contains a new exception in an introductory paragraph for discriminatory covenants affecting property. The ALTA Forms Committee engaged in lots of discussion on the wording of this exception and how to properly delete and repudiate a matter that is of record from policy coverage, and at the same time make it clear that ALTA and the policy do not perpetuate, condone, support, or republish any illegal discriminatory covenant in the public records, while at the same time preserving the portions of those covenants that are enforceable. So if you look at the new Schedule B policy exception, there is language acknowledging the recording of documents in the past containing illegal discriminatory covenants that limit ownership of the property. To give you some background, these type of restrictions were struck down by the Supreme Court in 1948 as unenforceable, and in 1968, Congress passed the Fair Housing Act banning covenants discriminating on the basis of race, color, religion, or national origin. The Fair Housing Act was subsequently amended to include discrimination based on family status and disability. It has been standard in the title industry to include language after a Schedule B exception for covenants, conditions, and restrictions, or CCRs, disclaiming any illegal discriminatory covenant that may be included in the CCRs. The new Schedule B exception language states that any discriminatory covenants contained in a document accepted in Schedule B are redacted, removed, repudiated, and not republished or recirculated, and only the remaining provisions are accepted from coverage. So there's a new broad definition of discriminatory covenant that is also added to the policy as further clarification of what constitutes a discriminatory covenant for the purposes of this exception. And again, this was discussed very thoroughly in the committee, in the Forms Committee meetings. The new definition goes beyond the Fair Housing Act classes and encompasses any CCRs under applicable law that illegally discriminate against a class of individuals based on personal characteristics. Additional classes such as gender identity and sexual orientation have been specifically referenced. There's a non-exclusive list that is intended to encompass federal, state, and local laws protecting certain classes of individuals. And as a result, specific language disclaiming any recorded discriminatory CCRs that had been previously used in a policy under each individual Schedule B exception is no longer needed, since the language is now built into the policy jacket. And this Schedule B exception will also apply to affirmative coverage over CCRs that the title company agrees to provide. For example, you may have a commercial developer that's looking to construct a multifamily or multi-use property in an area that is historically residential, with historic covenants that limit the use to residential only. And those covenants also happen to contain an illegal discriminatory covenant preventing use by a certain class of persons. If affirmative coverage is given over those CCRs in an ALTA 9 series endorsement or in custom coverage, this new exception will also apply to exclude coverage for any discriminatory covenants. And the revised language is also in line with the current political and cultural climate, with many states now enacting legislation to provide a means to remove old discriminatory covenants. We have the Uniform Law Commission that has a study group on the issue, and federal legislation was just introduced to map discriminatory covenants across the country. So this is a hot topic that the ALTA and the industry wanted to address in the new policies. Next slide. The 2021 policies also have 2 sets of optional preambles that can be used separately or together depending on whether the local market issues the loan policy with a Schedule B2 for subordinate matters. Both the preambles are bracketed, which means they are optional for title insurers to use in the form. The first preamble accepts to terms and provisions of leases and easements insured in Schedule A. Therefore, no specific Schedule B exception is required in the policy for the same. As we know, the policy ensures, if it's a leasehold, commercial leasehold policy, it ensures the leasehold interest for a term of years, but does not ensure the rights or obligations of the parties under the lease, such as a landlord's duty to paint or repair, or a tenant's duty to keep the premises in good repair. And the terms and provisions of the lease are a customary exception in commercial leasehold policies. The second preamble uses covered risk 10 priority to address coverage provided in B2 of the loan policy. Next slide, please. B2 provides coverage that the listed matters are subordinate to the insured mortgage or deed of trust, and the second preamble accepts to the terms and provisions of any subordination agreement identified in B2 of the loan policy, making it clear that the policy does not cover any loss arising out of those terms and provisions of a recorded subordination agreement that may be referenced in a B2 exception. Next slide. Condition 8, and also I wanted to say the 2021 owner's policy has the similar optional preamble for terms and provisions of lease and easements insured in Schedule A, and no specific exception needs to be taken if that language is used.
Okay, so in here we have on this slide the official placement in condition 1F of the loan policy and condition 1E of the owner's policy of our new defined term enforcement notice that we previously reviewed in relation to covered risks 5, 6, 7A, and 8. Next slide, thank you. In the definition of insured shown here has been expanded in both the loan policy and the owner's policy. In condition 1J of the loan policy, which is on this slide, the newly defined term affiliate has been added as highlighted on the slide. Affiliate is defined in both the new loan and owner's policy as an entity that is wholly owned by the insured, or that wholly owns the insured, or that is wholly owned by the same person or entity as the insured. So with respect to the loan policy, this makes it clear that if an affiliate of a lender acquires title through foreclosure or deed in lieu of foreclosure of the insured mortgage, the coverage will continue, and the affiliate has the protection of the policy. Next slide, please. And here's the owner's counterpart of the changes to the definition of insured. As shown, it provides that an affiliate is considered a successor insured, which was also the case under the 2006 policy, but this actually represents an increase in coverage as the 2006 policy contained the caveat that the deed to the affiliate had to be delivered without payment of actual valuable consideration. And the 2021 policy does not include that condition. Additional enhancements to the coverage are shown in highlighted items 3, 4, and 5, which provide that the policy coverage now extends to a spouse receiving title in connection with the dissolution of marriage, a beneficiary under a transfer on death deed or other transfer that is effective on the death of the insured, or the interest acquired by an insured from another insured. And this last provision may apply if the insureds are co-tenants or if the insureds own different interests. Next slide, please. As briefly touched on before, the definition of public records has been modified in the policies to provide further clarity. Courts have often misapplied or misinterpreted what constitutes public records, and this modified definition distinguishes between those records that are public records for the purposes of title insurance policies versus other governmental records that are not intended to be and are generally not construed as within the scope of public records for the limited purposes of title insurance. Now, state is a new definition for the 2021 policies. It was introduced as a result of the McGirt Supreme Court case and is meant to exclude any tribal governmental authority. While the holding in McGirt was narrow in scope to address criminal jurisdiction of the Muskogee under the Major Crimes Act, the additional impact of the case was the holding that the Creek Reservation was never disestablished, which raises issues beyond the specific holding in this case. The Muskogee or Creek Nation now has the ability to assert civil and administrative jurisdiction over all land contained within the boundaries of its reservation. And as much of the state of Oklahoma now lies within the boundaries of the Native American reservation, how does this affect applicable laws, and who do these laws apply to? Questions raised include taxing authority, land use, zoning, access, land records, and recordation, among others. Therefore, condition 1S in the loan policy and 1N in the owner's policy were changed with this in mind to clarify that the term state only includes a state or commonwealth of the United States and also includes the District of Columbia, Puerto Rico, the U.S. Virgin Islands, and Guam.
Next, we're going to talk about the changes to Condition 8 in the owners and loan policy. And there's been quite a few changes made, which are a result of claims and litigation. And the changes are intended to reduce litigation, which is beneficial to the insured and the title insurer. So first, preamble language that's on the screen has been added to both the owners and loan policy, defining what title insurance is and what it is not. The language clarifies that the policy is a contract of indemnity and the title company is not liable for claims of negligence and negligent misrepresentation. This language may look familiar because it's already been included in the 2016 commitment, and it was included in response to several court cases in various states holding the title company liable under theories of negligence for omission of a matter in Schedule B rather than limiting liability under a contract liability theory. Now this language is also rolled over into the policy. Next slide. Section 8A of the loan policy addresses the extent of company liability for loss or damage. A new term has been added at Romanet 3 of Section 8A. Instead of measuring the loss as the difference between the value of the title as insured and the value of title subject to the matter insured against under the policy, the term value has been changed to fair market value. Rather than leave it to the courts to interpret the meaning of value, the policy now refers to fair market value which is intended to limit litigation for both the insured and insurer over what value to use. Next slide. The same change for fair market value has been made in the owner's policy condition 8A. Next slide. Switching back to the loan policy, there's been a new provision has been added that specifies the date of loss for the lender. And again, this change is intended to reduce litigation over any ambiguity in the policy and the claim setting. Under this new provision, the fair market value will be calculated either as of the date the insured lender acquires title, out of foreclosure, or by deed in lieu, or the date the lien is extinguished or rendered unenforceable by a loss covered under the policy. And this is consistent when the lender suffers a loss under the policy provisions. Next slide. In the owner's policy, there's a new condition 8B, which provides that the insured's loss will be calculated as the fair market value on the date of discovery of the defect, lien, or encumbrance or adverse claim. This language is new and represents the adoption of the majority rule in case law as to when a loss should be determined under the policy. And again, it is intended to reduce litigation over this issue. Next slide. Condition 8C of the owner's policy is another new provision which is very beneficial to the insured. If the title to land is void and there's a total title loss, the insured can elect to use the data policy for calculating the fair market value of the title. This change recognizes that a total title loss can be devastating for the insured, and in a down market, having the option to elect the data policy as the date to calculate the loss is beneficial to the insured. Likewise, if market value is soaring, as it is nowadays, the insured can elect to take advantage of the date of discovery provision. Next slide. Another benefit in the newly revised policy is that the curative penalty provisions in Condition 8C have been increased in the loan policy. If the company is unsuccessful in establishing title or the lien of the insured mortgage as insured, the amount of insurance will now increase by 15%. The 2006 versions provided for an increase of 10%, and this is of course beneficial to the insured and intended to take into account inflation and cost of living increases. Next slide. The owner's policy at Condition 8A also has a corresponding change providing for the increase of 15% under the same condition. And 8D also provides the owner with just another date for calculating fair market value. The insured has the option to use the date the settlement action proceeding is concluded or the date the company received the notice of claim. Again, this is very beneficial to the insured in that they have the flexibility to select a date that can maximize their policy recovery. Next slide. Another beneficial condition was added in number 10 in the loan policy, and it's beneficial to the insured lender. This provision was added based on comments provided by the Lenders Bar and Lenders Council through the American College of Mortgage Attorneys. There had been case law in several jurisdictions holding that a lender making a full or partial credit bid at foreclosure sale extinguished policy coverage, which was not favorable to the lender. Under new condition 10, the amount credited against the indebtedness as a result of a foreclosure or a deed in lieu will not reduce the policy amount or terminate the policy.
Condition 15A of the loan policy, choice of law, has been modified to clearly provide the state law of the state where the land is located governs the interpretation, rights, remedies, or enforcement of the policy. This provision is necessary because of the increase in multi-state and cross-border transactions. And then condition 15B, choice of forum, which also includes the new defined term state, clarifies that any litigation or other proceeding brought by the insured against the company in a state court must be filed only in a state court as the term state is now defined in the policy. Next slide. And the same modifications as to choice of law and choice of form were made to the owner's policy under condition 16, as shown here. Now, condition 17 of the loan policy and corresponding condition 18 of the owner's policy reflect that claims and disputes must be brought in an individual capacity and may not be brought as a class action. As well, there can be no joinder or consolidation with claims or controversies of other parties. Next slide. The arbitration provision, which is an optional provision under condition 18 of the loan policy and condition 19 of the owner's policy, is not new, but has been revised to provide greater clarification, including specification that the arbitration must be conducted pursuant to ALTA rules and handy links for those rules. And here it is under the owner's policy.
Now we'll proceed to wrap up our discussion on the forms. Today we focused on the standard-based policies for commercial transactions, but there were numerous policies that were revised and to conform to changes made in the base policies. And they are listed on the slide here, and they're also available for review on the ALTA website under the policy forms. Next slide. And now we will talk about endorsement revisions.
All right, so endorsement changes were made to several of the ALTA series endorsements to make them conform to the changes to the 2021 policies, including with respect to the operative law changes in the new definition of state, as previously discussed in relation to the McGirt case. Changes to endorsements affecting commercial transactions are shown on this slide and on the following two slides. And then the next. Okay, and then moving on, we also have a few new endorsement forms as well, as shown on this slide. The ALTA 34.1 identified exception and identified risk coverage endorsement is a companion form to the ALTA 34 identified risk coverage endorsement. And then the ALTA 47 and 47.1 operative law series endorsements for the owners and loan policies respectively, again, relate to the McGirt case and were added to apply the definition of state and the related conditions to those policies yet being issued under the 2006 forms. With respect to the ALTA 3 zoning series, we wanted to specifically bring to your attention the fact that it includes a new definition of zoning ordinance, which serves to further clarify the meaning of a zoning ordinance as it applies to the policy. And the endorsement also include the new defined term state. And then last but not least, the ALTA 28.1 encroachments, boundaries, and easements endorsement has been revised with respect to the Section 4 carve-out. And the change shown here has been made in order to further clarify the carve-out provision and to make it consistent with the ALTA 28.2 and 28.3 endorsements in the series.
And that concludes our discussion, we'll turn it back over to Jeremy.
There we go. All right. Well, thank you, Jan and Wendy. A lot of changes to the forms and associated endorsements. As we mentioned, we will hold a little time for Q&A. So if you have any questions about any of the changes that have been published, please submit them in the questions box. If you don't have any now, feel free to email ALTA at forms@alta.org, and we can get your questions answered. And as what Wendy mentioned, you can access the forms and comparison charts at alta.org/policy-forms. Kristen said she appreciates the Beatles references. So. And I'm sorry, I think I'm catching a little bit of an echo, so hopefully out there it's not too annoying for everyone out there. James asking to obtain the slides. Yes, you can either download them now from the handout section, or you'll get an email tomorrow with a link to access a PDF of the PowerPoint. If you had to pop in and out of today's presentation, or if you think others in your office would benefit from listening, as I mentioned, you'll get a recording in that email, a link to the recording in the email, and you feel free to share with your staff. It's going to be important to not only for your staff to know about the changes and understand the changes, but then to be able to communicate them to your customers going forward. Obviously, as they mentioned, there'll be a process to get these implemented and filed with the states. In the meantime, you'll probably want to work with your underwriters to get educated on coverages. Wendy and Jan, anything else you would like to add there as far as what agents or attorney agents can be doing now to get ready for the forms?
Well, I know the title underwriters are now working on getting the forms filed in the states where they're required to be filed, and looking at whether certain bracketed information that's optional should be included in those forms. So I would agree with what you're saying. The agents should be contacting their underwriters, and I assume they'll be sending out information in bulletins, letting them know on the status and when they can start using the forms.
Okay. This acronym always makes me chuckle. So the PACA PASA coverage. James asked, is this covered more in the jacket? Since it's covered more in the jacket, will there still need to take exception to it in Schedule B?
The intent is that the exclusion replaces the exception, but again, check with your underwriter and see what their official position is on that.
Okay. Don't have a whole lot of questions coming in. I'm guessing probably right now it's there's a lot of information to take in, and
the audience is stunned.
As you guys mentioned, the last revision was 2006, so and the one previously, 15 years prior to that, so every 15 years. Seeing no more questions, we'll just wrap up here. Do want to make everyone aware of a few educational opportunities coming up. We'll have the final of our commercial network webinars next month, and as Jan and Wendy mentioned, we'll dig into the 47 series endorsements and addendums following the U.S. Supreme Court decision in the case McGirt versus Oklahoma, and we have it appropriately titled the Dirt on McGirt. You can register now for that webinar on ALTA's website at alta.org/webinars. And that will then lead us up to ALTA 1 in October in New Orleans. Obviously, we know the COVID situation is still a little bit fluid, but we still anticipate being live in person there. We will have a virtual component, but we hope to see as many as possible in New Orleans. And we will have a education track dedicated to the commercial market at ALTA 1. Registration is open, and you can go to alta.org/1 for more information on that. Sorry, just checking the questions box. Roger asked if there's a comparison chart. Yes, on the ALTA forms page, there are comparison charts for both the loan and owner's policy. There's the red line changes and then the clean versions of both. So good documents there to compare and contrast. And Joe said, you know, great to see the decertification date for 2006 forms announced for 12/31/2022. Seems like a long time away, but summers go fast, and we'll be turning the calendar before we know it. Roger, the homeowner's policy, that's a good question. I'll look into that, because you're right. I think there was actually the two. Jan or Wendy, do you know if there's going to be a comparison chart for the homeowner's policy? I guess that's the enhanced version of the owner's policy.
I'm not sure. I don't know if that was discussed or it's being worked on.
I think there were comparison charts for the endorsements that recently came out, though. Is that
the red line? Yes, there are red lines now posted.
But I haven't heard anything about the homeowners comparison either.
All right, Roger.
There might be a red line on, I'm sorry, there might be a red line on the forms page, but I don't think there's a chart.
Yeah, Roger, we'll follow up with you after the webinar. Good question. No more questions. We'll wrap up. Again, thank you, SoftPro, for sponsoring today's webinar. Jan and Wendy, thank you for taking a little bit of time, and thank you for all of your dedication to the industry and help with the publication of the new forms. All right, take care, everyone.
Thank you.
Yep.
Right. Bye.
Right.
Bye-bye.
Bye.